and when the performance becomes due, the promisor offer to perform his obligations, but the promisor refused to accept the performance. Conditions to be satisfied for a valid tendered or attempted performance. It must be unconditional. It must be offered be to repay the principal amount of loan. This is an unvalid tender since the whole amount is interest is not. Conditions to be valid, satisfied for a valid tender or attempt performance. It must be made at proper time and place. If a promiser wants to deliver goods at to it and not a valid demand. Reasonable opportunity to examine goods. It must be whole obligations acts as by labor to put an end of the contract. By whom a contract will be performed. Section 14, 42, 41 and 42. By whom, by whom contract may be made or performed. Section 40 and 41 and 42. Promisor. Promisor himself. If there is not something in the contract to show that it was the intentions of the party that the promise should be performed by the promisor himself, such promise must be performed by the promisor. This means contract which involves exercise of personal skills or diligence or which are found on personal confidence between the parties must be performed by the person promisor himself. Agent, where the personal consideration is not the foundation of the contract, the promisor or his representative may employ a competent person to perform. Legal representatives. A contract which involves the use of personal skills or are founded on personal consideration where comes to an end of death of promise. As regard any other contract, the legal representative of disease promisers are bound to perform unless contrary intention appear from the contract, section 32 para 2, but their liability under a contract is limited to the value of property they inherit from a deceased partner. Third person, effect of accepting performance from third person, section 41. When a promisee accept performance of the promise from a third person, he cannot afterward enforce it against the promiser. That is performance by a stranger if accepted by the promiser. This results in discharging of promiser through the latter had neither authorized nor ratified the act by third party. Joint promiser. When two or more persons have made a joint promisee Then, unless a contrary intentions appear by the contract, all such person may must mostly jointly fulfill the promise. If any of them dies, his legal representative must jointly with the surviving promiser fulfill the promise. If all of them died, the legal representative of all of them must fulfill the promise jointly. Distinction between succession and assignment. Distinction between two legal concepts, visa, succession and assignment, may be noted carefully. When the benefits of a contract are succeed to be to by a process of law, then both burden and benefit attaching to the contract may sometimes devolve on their legal hire. Suppose a son succeeds on or to the estates of the partner after his death, he will be able to pay the debts liabilities the father owned during his lifetime. But if debts owned by father exceeds the value of states inherited by the son, then he would be called upon to pay the excess. In other words, the liability of the son will be limited to the extent of property inherited by them. मतलब जितनी प्रॉपर्टी बाप से मिली उतनी तक ही बेटा बंद होगा ना। जो बाप से मिला 1 करोड़ और बेटा 4 करोड़ का कर्ज कहाँ से भर देगा, बात ये पड़ जाती है भाई. In the matter of assignment, however, the benefit of a contract can only be assigned but not the liabilities thereunder. This is because when liability is assigned, the third party gets involved therein. Thus, a debtor cannot relieve himself of his liability to creditor by assigning to someone else his obligations to repay the debt. समझा नहीं होता रहा. However, the benefit of a contract can only be assigned but not the liability. In the matter of assignment, however, the benefit of a contract can only be assigned but not the liability. ठीक है. This is because when liability is assigned, a third party gets involved therein. Thus, a debtor cannot relieve himself of his liability to creditor by assigning someone else's obligation to repay the debt. On the other hand, if a creditor assigns the benefits of a promisor, on the other hand, if a creditor assigns the benefits of a promise, he thereby entitles the assignee to release the debt from the debtor. But where the benefit is coupled with a liability, or when a personal consideration has entered into the making of the contract, then benefits cannot be assigned. Liability of a joint promisor and promisee. Evaluation of joint liability. Section 42. If two or more persons have made a joint promise, ordinarily all of them during their lifetime must jointly fulfill the promise. After death of any of them, his legal representative jointly with survivors and survivors should do so. After the death of the last survivors, the legal representatives of the original co-promisor must fulfill the promise. We have seen that Devolution of joint liability section 42 to a person. After the death of the last survivors, the legal benefit of all original sponsor must fulfill the promise. ठीक है. We have sent section 42 deals with voluntary discharge of obligation by joint promisor. But if we do not charge their obligations on their violations, what will happen? This is what section 43 resolves. Anyone of the joint promisor may compel to perform section 43. When two or more person makes a joint promise, the promisee may, in the absence of the expressed agreement, क्या है? When two or more person making promise, the promisee may, in the absence of the express agreement, to the contrary compelled element more of such joint promiser to perform the whole of the promise. Each promisor may compel contribution. Each of two or more joint promisor may compel every other joint promisor to contribute equally with himself to perform or be performed to the performance of the promise, unless a contrary intention appears from the contract. In other words, if one of the joint promisor is to perform the whole contract, he can call contribution from other. And two or more persons make a joint promise, then promisor may, in the absence of express agreement to the contrary, compel any one or more of the joint promisor to perform the whole. Each promisor may compel contribution. Each of the two or more joint promisor may compel every other joint promisor to contribution equally within himself to perform of the promise, unless a contrary intention appear. The third person accepting performance from third person. ये हो गया था devolution हो गया था ये भी हो गया था. Sharing of loss by default in contribution. If anyone of two or more partner, if anyone of two or more joint promisor makes default in such contribution, the remaining joint promisor must bear the loss rising from If anyone of two or more joint promisor, Calico. If any one of two or more joint promisor makes default in such contribution, the remaining joint promisor must bear the loss arising from such default in equal case. Explanation for this for explanation to section 43. Nothing in this section prevent surety from recovering from the principal's payments made by the surety on behalf of the principals on entitling. If any one of two or more joint promisor makes default in such contributions, the remaining promisor must bear the loss arising from such default in equal share. Explanation for section 43. Nothing in this section will prevent a surety from recovering from his principal debts. Principal payment made by surety on behalf of the principal or entitle the principal to recovering anything from the surety on account of payment made by the principal. We thus observe that the effect of section 43 to make the liability in the event of a joint contract, both joint and several, insofar as the promisee may in the absence of the contract may in the absence of a contract to the contrary compel any one or more of the joint promisor to perform the whole of the promise. Effect of release of joint promisor section 42. The effect of release of one of the joint promisor is detailed with section 44, which is stated below. When two or more persons have made a joint promisor, a release of one of such a joint promisor by promisor does not discharge the other joint promisor or joint promisor. Neither does it free the joint promisor, so it released from responsibility to other joint promisor or promisor. Example समझते हैं. Example समझते A, B, C jointly promised to pay 9 lakh to D. D released A from the liability. In case of C, release of A does not discharge B, C from the liability. They remain liable to pay the amount of 9 lakh to D, and true, A is not liable to pay D, but remaining liable to B and C. That is, he is liable to make contribution to other promisors. Right of joint promisor. The law relating to devaluations of joint rights is contained in section 45, which is reproduced below. When a person has made a promise two or more persons jointly, then unless a contrary intention appears from the contract, the right to claim performance rests as between him and them, when them during their joint lives and after the death of any of them, with the representative of such deceased person jointly with the survivors of survivors and the law after the death of last survivor with the representative of all jointly. A considerations of 5 lakh rupees lent to him by 5B and C. Promise B and C jointly to repay them the sum with interest on a specified day, but B dies. Right of रुक जा गलत पढ़ रहा है गलत भाई नींद इतनी आ रही है मैं क्या बताऊँ. Right of joint promisor. The law relating to the devolution of right contained in section 45, which is reproduced below. When a person has made a promise or to two or more persons jointly, then unless a contrary intention appear from the contract, the right to claim performance rests as between and them with them during their joint lives and after the death of any of them. Joint lives with any of them with the representative of such deceased person jointly with the survivors or survivors and after the death of last survivors. भाई सब्सक्राइब कर देना जो भी चैनल पे नए हैं. Death of last survivor is the representative of all jointly. A consideration is A in consideration section 5 lakh rupees lent to him by B and C promised So B and C jointly to repay them. That state some with the interest on a specified day, but B dies in a such case. Right to demand repayment shall rest with B legal representatives or jointly with the C during C's lifetime, and after the death of C, the legal representative of B and C jointly. Time and place for performance of the promise. The law on the subject is contained in section 56, 46 to 50, explained below. Time of performance of promise when no application is to be made and no time is specified, section 46, whereby the contract of a promisor is to perform his promise without applications by the promisee and no time for performance is specified. The engagement must be performed within a reasonable time. Explanation to the section 46. The expressions reasonable time is to be interpreted having regards to the fact and circumstance of a particular case. Time and place for performance of the promise, where time is specified and no application is to be made. Section 47. When a promise is to be performed on a certain day and the promiser has undertaken to perform it without application by the promisor, the promiser may perform it any time during the usual hour of business on such a day and the place at which the promisee ought to be performed. If the delivery of goods is offered, say 8 p.m., the promisee may refuse to accept the delivery for the usual business hours, and moreover, the delivery must be made at a usual business hour. Application for performance on certain days to be proper time and place. Section 48. When a promisee is to perform on a certain day and the promisee has not undertaken to perform it without applications by promisee, it is a duty of promisees to apply for performance at a proper place within the usual hour of business. Explanation. Section 48 states that the question is the proper time and place in each particular case a question of fact. Place for performance of promise where no applications is to be made and no place fixed for performance. Section 46. When a promisee is to performed without application by the promisee and no place is fixed for performance it is the duty of the promiser to apply the promise to appoint a reasonable place for the performance of the promisee and to perform it such a place it at such a place when a promise is to performed without application by the promisee and no place is fixed to perform the when a promise is to perform without application by the promisee and no place is fixed for the performance of it, it is the duty to a performer promiser to apply to promisee to appoint a reasonable place for the performance of the promisee and perform it at such place. Interdicted delivery of 1,000 mounts of jute to B on a fixed date. A must apply to B to appoint a reasonable place for the purpose of receiving it and must deliver it at such place. Performance in manner at the time prescribed or sanctioned by promise. Section 50. The performance of any promise may be made in such manner or at any time which the promise is prescribed or sanctioned. Performance of reciprocal promise. The law on the subject of contained in section 51 to 58, the provision thereof are summarized below. Promiser not want to perform unless reciprocal promisee ready and willing to perform. Section 51. When a contract consists of reciprocal promise to be simultaneously performed, no promiser needs to perform his promise unless the promisee is ready and willing to perform his reciprocal promise. Means A and B contract that A shall deliver the goods to B, B to be paid by B on the delivery. A needed not deliver the good unless B is ready and willing to pay for the goods on the delivery. Order of performance of reciprocal promise. When the order of performance of reciprocal promise is expressly fixed by the contract, they shall have to be performed. They shall be performed in that order, and where the order is not expressly fixed by the contract, they shall be performed in that order which the nature of the transaction requires. Order of performance of reciprocal promise. When order of performance of reciprocal promise is expressly fixed by the contract, then contract they shall be performed in that order, and where the order is not expressly fixed by the contract, they shall performed in that order which the nature of the transaction required. Liability of party preventing event on which the contract is take to effect section 53. When a contract contains reciprocal or promise, another one party to the contract prevents the other from performing his promise, the contract becomes voidable at the option of the party so prevented, and he is entitled to compensation from other party and from loss. Contract contains reciprocal promise and liability of party preventing event on which the contract is to take effect section 53. When a contract is contained reciprocal promise and one party to the contract prevents the other from performing his promise, the contract becomes voidable at the option of the party so prevented, and he is entitled to compensation from other party and any loss he may sustain in consequences of non-performance of the contract. A and B contracts that B shall execute some work for A for 1,000 rupees. B is ready and willing to execute the work accordingly, but A prevents him from doing so. The contract is voidable at the option of B, and if he elects to resign it, he is entitled to recover from A compensation from any loss which is he is incurred by its non-performance. Non-performance of the contract. ठीक है. In a contract of sale of standing timber, the seller is to cut and cord it where up, buyer take it away and pay for it. The seller cords only a part of the timber and neglect the cords and cord the rest. In that event, the buyer may avoid the contract and claim compensation from the seller for any loss which he may have sustained for the performance of the contract. Effect of default as to the promisee, which should be performed in the contract, consisting of reciprocal promise. Section 54. Section 54 applies when the promisee where are reciprocal and dependent. If the promisee who has to perform his promise before the performance of the performance of other promisee fails to perform it, he can claim contract cannot claim contract performance of other. The promisee and is also liable for compensation of non-performance. समझेगा इश्क मेरा दीवाना हुआ तुम्हारी दीवाना क्या गिरी दहलीज पे मेरे दिल की हम गम न सकता मैंने जिया जिया कैसे जिया कैसे जिया मेरे हम गम सच्ची सी है जो तारीफें उनसे जो मैंने करी आसमां मिला ज़मीन को मेरी यादें यादें मेरे हमगम तेरे नाम पे मेरे दिल की लिख ली मेरे हमगम न सीखा मैंने जीना जिया कैसे जीना जिया कैसे जीना मेरे हमगम. Order of performance of reciprocal promise. When the order of performance of reciprocal promise is expressly fixed by the contract, then the contract they shall be performed in order that and where the order is not expressly fixed by the contract, they shall be performed in that order in which the nature of the transaction required. Liability of party preventing event on which the contract is to take effect. Section 53. When a contract containing reciprocal promise and one party to the contract prevent the other from performing his promise, the contract becomes voidable at the option of other so prevented, and he is entitled to compensation from the other party from any loss he may sustain in consequences of non-performance of the contract. Effect of default as to that promise which should be first performed in the contract consisting of reciprocal promise. Section 54. Section 54 says that when the promise and reciprocal promise and the promise are dependent, if the promisee who has to perform his promise before the performance of the other promise fails to perform it, he can claim contract performance of other promise and he is also liable to compensation for his non-performance. दीवाना हूँ पहले रंग में एक दिन ऐसी जीत आएगी भुला देगी सारे हार के किस्से. Liability of party preventing event on which the contract is to take effect. When a contract is eligible promise and one party is to contract effect of default as to the promise which should be first performed in the contract consisting of reciprocal promise. Section 54. Section 54 applies when the promises are reciprocal and dependent. If the promise who has performed his promise the performance of the other promise fails to perform it, he can claim performance. He can claim performance of the other promise, and he is also liable for compensation of his non-performance. Section 54 applies when the promises are reciprocal and dependent. If the promisee was performed his promise before the performance of other promisee fails to perform it, he can claim performance of the other contract. Performance of other boundaries and he is also liable for compensation of non-performance. They have B ships to take and convey from Kolkata to Mauritius. A cargo is provided by A. B receiving a certain freight of its cargo. Any cargo for the ship, A cannot claim on the performance or B promise and must make compensation to B for the loss which be sustained by the non-performance of the contract. The effect of failure of performance. Effect of failure to performance at a time fixed in contract and which time is attention. Oh, how to set up a gambhir ananasi game में लगती है द्वारा दिन पंच माफ करना गाने में थोड़ी सी क्षमा प्रार्थना Each session fixed for performance of the time fixed when the contract in which times is the sanction section 52 55. Now the subject containing section 55 so which is reproduced below. When a party to contract promise to do certain things at a before the specified times and fails to do any such things at or before the specified time, the contract or such so much of it as not been performed become voidable at the option of the promisee or if the intention of the party was the time should be the essence of the contract. Which of the such failure was the time is not essential. If it was not the intentions of the such parties that the time should be the essence of the contract does not become voidable by the future by the failure to do such things at before the specified time. But the promise is entitled to compensation from the promise for any loss occasioned by him by such failure. एक ऐसी जीत आएगी मिला देगी सारे हार के किस्से. Effect of acceptance of the time of the year agreed upon in such case contract voidable on the grounds of promise of failures to perform this promise at the time agreed. The promisee accept the performance of such promisee at any time or in other than agreed. The promisee cannot claim compensation for any loss occasioned by the non-performance of the promisee at the time agreed unless at the time of acceptance he give notice to the promisor of his intention to do so. Agreement to do impossible at section 56. The promise of performance may be for of two types, namely initial impossibility and subsequent impossibility. Initial impossibility. Impossibility existing at the time of the contract when the parties agreed upon doing of something which is obviously impossible in itself, the agreement would be void. Impossible. Impossible is means itself in the nature of the things. The fact of impossibility may be known to the parties. A Hindu who was already married to be an Hindu girl according to Hindu law being married could not marry B within case must make compensation to B for loss caused by her by the non-performance of the contract. If known to the parties, it would be observed that an agreement constituted quite unknown to the parties may be impossible or being performed and hence void. If known to the parties, both the promisor and promisee are ignorant to the of impossibility of the performance, the contract is void. If known to the party, promisor only.